BACDL Circuit Court Judicial Candidate Forum. My name is Jason Blank. I am the president of the Broward Association of Criminal Defense Lawyers, and it is my privilege to host this event tonight and to moderate this event. I can tell you that the board has worked very hard on putting this event together. We are excited to challenge the candidates tonight with the questions that we are planning to ask them. And one of the things that we are going to do here tonight is to live stream this forum so that all of our membership and all the public can hear the responses that the candidates have, not just tonight, but on any replay that they choose to watch. Tonight's an opportunity for those candidates running for the Broward County Circuit Courts to enlighten the public on various issues, both personal and professional, that will play a role in their job as judge if they are granted the confidence of Broward's voters. This forum will be run in a unique fashion with rules that have been previously provided to the candidates. The candidates will be called by group in an order that has been previously determined by random drawing. One group will be up, with the next random group being on deck. Each group will be posed the same 3 short questions. Not my fault. I didn't do it. Is it this one over here? I'm getting pointed to by some people.
Cell phone.
No, my cell phone's off, guys. This is not my first rodeo. I think it might be this one here, number 11. Let's see. Should I unplug it? Let's unplug that puppy and let's see if that does it. There we go. All right. As I was saying, each group will be posed the same 3 short questions requiring only a few word answers. So every group will receive the same 3 short questions. No questions have been previously provided to the candidates, and they will be hearing them for the first time as they are asked here tonight. After those 3 short questions are posed, each group will then be asked 2 substantive questions, and the candidates will have a chance to answer those questions each. Each candidate will have 1 minute to respond to each question asked, and will be given a signal when they have reached 30 seconds and at the conclusion of their time. Our lovely board member, Raquel Hilton, is going to hold up a yellow card when the candidate has reached 30 seconds, and will hold up a red card to denote that their time has expired. And like the 4th District Court of Appeal, I will say, thank you, your time has expired, and you will be expected to stop talking, candidates. The questions have been vetted and selected by the BACDL Executive Board, and we are confident that the questions we are going to ask here are going to be very probative and questions which you may not have received at any forum or may not have heard asked of the candidates at any forum attended prior to tonight. We ask that the audience keep any responses, positive or other, to themselves, and that any applause, if you so choose there to be a need for some, be reserved until the end of the group's time on stage. Let me take this time to thank everybody for being here, really, and helping make this event a success. As the group of criminal defense lawyers represented in Broward County, often people think that we are the redheaded stepchild of the legal system, but it's our position that we are the ones who have the most powerful voice here in Broward County, and we are very, very curious to hear what these candidates have to say in reference to many of the issues that we intend to question them on tonight. So, without further ado, let's get started. I'm going to call the groups 2 at a time, ask them to come up and have a seat, with the first group called sitting at the red, and the second group called sitting at the other color. I'm colorblind, I don't know if that's green or tan. We're just going to assume that it's light. So the second group sitting at the light colored tablecloth, and we will get started. So with that, I'm going to ask for group 39 and group 8 to come on up on stage. Group 39 is Susan Lynn Alspector and Camille Coolidge Shotwell. And group 8 is Judge Ernest Albert Cholera and Alan B. Schneider. Yeah, clap now if you want. I mean, it'll be like you're winning awards. Thank you. So we may have to pass that one microphone back and forth, and Judge Cholera, you may have to grab that microphone when your time is up, because I guess that other microphone is not working. But all right, so let's start. Let's start with group 39. We are going to start with Ms. Alspector. Let me ask you this: when was the last time you tried a jury trial?
Never.
Can you use the microphone, please, at the crowd can hear?
I've never tried a jury trial. I'm a marital and family attorney, so I try bench trials and sometimes long evidentiary hearings.
Thank you. And Ms. Coolidge Shotwell, when was the last time you tried a jury trial?
I actually tried a jury trial in Palm Beach County, I want to say
probably 2005.
And how many jury trials have you had?
I wasn't, that wasn't my last jury trial I had, was last year in the federal system, but we ended up, after we picked the jury, we ended up settling that case. So I've had 3 jury trials in my career. I'm also a family law attorney, and most of my trials are bench trials as well as civil.
I'm going to ask the candidates to please respond to the question asked only. How many of those jury trials were for criminal cases?
None.
Okay. Let's go back to Ms. Alspector. The first question for both candidates, and I'm going to ask Ms. Alspector to respond first, then Ms. Coolidge-Shotwell, and then for the second question, we'll reverse the order, and that we'll keep that pattern going throughout. In your personal life, please tell us about a time that you became involved in the criminal justice system, and will that play a role in your judicial philosophy? If so, how? Ms. Alspector?
I cannot recall a time that I have been personally involved or that a family member has been personally involved in the criminal system. So the best and the closest I have been is obviously sitting in the jury box, but after voir dire was never picked.
How would the lack of your involvement in the criminal justice system affect your judicial philosophy?
Well, my judicial philosophy is, first of all, it definitely starts from a temperament. So certainly it's important to listen to people. It's important to be open-minded. We have a very diverse county, and my life experience is probably not that of any other person who's sitting in this room. And it's my job to listen to people, because if you're going to reach outcomes that require you understanding facts and applying law, then you need to understand what the facts are, and that means from listening.
Thank you, ma'am. Ms. Coolidge-Shotwell, I pose the same question. Your personal life, tell us about a time you became involved in the criminal justice system, and will that play a role in your judicial philosophy? If so, how?
Of course it will play a role in my judicial philosophy. My first experience with the criminal justice system, where I had a great appreciation for the system, is when, a lot of you already know, my husband's a police officer, was involved in an officer-involved shooting where he had to kill the assailant, and we had to go to the grand jury, because every officer-involved shooting goes to the grand jury. And that whole process gave me a very healthy appreciation how important our system is and how important it is that everybody do their job. And I think that is part of my judicial philosophy, is that accountability for people to do their job and do it well.
Thank you. Ms. Coolidge-Shotwell, we're going to keep the heat on you. The NACDL, the National Association of Criminal Defense Lawyers, issued a report regarding the diminishing presence of the criminal trials due to courts giving harsher sentences after a defendant exercises her right to a fair trial. Have you personally experienced or become aware of the trial tax on defendants? What specific assurances will you give to ensure a defendant exercising their constitutionally guaranteed right to a fair trial will not be given a harsher sentence because of his or her choice?
Well, the sentencing guidelines are statutory. We have those guidelines as a judiciary to follow, but where there's discretion is when you give that person and their family an opportunity to provide their background so that you can have a healthy understanding of what brought them to the judicial system, and giving them that opportunity to share their life experience to find out whether this was a mistake or whether they're life criminals. You've got to exercise that discretion on a case-by-case basis based on each individual and their background, and that needs to be heard, because how can you exercise discretion without knowing that?
Ms. Alspector, I would pose the same question to you. Have you personally experienced or become aware of the trial tax on defendants? And what specific assurances will you give to ensure a defendant exercising their constitutionally guaranteed right to a fair trial will not be given a harsher sentence because of his or her choice?
I need you to read the whole question. That wasn't
Sure.
all.
The National Association issued a report regarding the diminishing presence of the criminal trials due to courts giving harsher sentences after a defendant exercises his or her right to a fair trial. Have you personally experienced or become aware of the trial tax on defendants? And what specific assurances will you give to ensure a defendant exercising their constitutionally guaranteed right to a fair trial will not be given a harsher sentence because of his or her choice?
Thank you for the question.
You're welcome.
Okay. The largest issue is the right to a fair trial. And everyone still has the right to a fair trial regardless of how they decide to proceed in court. And that should be done on a case-by-case basis. So again, discretion is important, but the fact is even-handedness is the most important thing. So there should be no presumption, there should be no assumption regarding what a defendant may or may not do. The defendant presents himself and presents his case or chooses the path that he wants to go. And then a judge has to decide based on fairness and justice what is the appropriate punishment.
Thank you. We're going to move on to Judge Cholera at this time. Judge Cholera, we're going to pass that microphone down to you.
I'm going by the redheaded.
All right. Well, Judge Cholera, thank you. And I just want to confirm that your opponent, Alan Schneier, was unable to make it tonight, so Judge Cholera is opposed, but was the only candidate in Group 8 to appear tonight. So Judge Cholera, I'm going to ask you a couple of questions, and I'm going to ask you the same 3 short questions we started with the last group. When was the last time that you tried a jury trial?
I'm going to say about 4 years ago. It was a criminal case, and I believe halfway through it, we pled it out.
And in your professional career as a lawyer, how many jury trials would you say that you tried?
I've been a lawyer like almost 40 years. I'm going to maybe 20.
Okay. So, Judge, it's been proven that indigent defendants around the state of Florida often receive higher sentences than those represented by private counsel. What steps have you taken to ensure that this does not happen in your courtroom? And what can you do better to ensure the equal treatment of all those appearing in front of you?
I don't treat anybody differently, whether they're represented by a public defender or whether they're represented by private counsel. They file anything that they file, downward departures, I treat them all the same. Bonds, I treat them all the same, bond motions. If they were to plead open to me, I look at all the facts. I could care less who's representing them.
I'm going to pose the same question to you that I posed to the last group regarding the NACDL report that was issued recently. Have you personally experienced or become aware of a trial tax on defendants after exercising their constitutional right to a trial? And what specific assurances can you give to the voters of Broward County that a defendant exercising his constitutional right to a trial will not be given a harsher sentence for doing so?
I pay strong attention to certainly the score sheet. Also, if someone gets convicted, they want to file a downward departure or motion for alternative sentence, I consider it. And whether they've been convicted by a jury or whether they've entered into an open plea and they filed a downward departure, I consider the facts. And if they're entitled to a downward departure, if they're entitled to an alternative sentence, whether they've been convicted by a jury or pled open to me, it makes no difference. So the best way I can answer that is that I don't consider anybody going to trial that they should be taxed for it or punished for it.
Now, Judge, we're gonna get a little personal here because part of what the Broward voters want to know is who you are as a person. So the next question is one of a personal trait. What is your biggest character flaw, and how do you address it?
My biggest, other than being married, no, I'm sorry. My wife doesn't use the internet. My biggest character flaw actually occurred today. It was a long time here with the campaigning and everything. It was a long, long day today, long week with the live streaming trial. And I started to lose it a little bit today. A defense attorney wanted to revisit something where the client had given up their right at the time of their plea to any credit for time served. Now they were up on a VOP, and they wanted to revisit that to try and get some credit for something they gave up at the time of the plea when they negotiated their plea. And I said about 3 times, I am not going to consider it. And they kept pressing, and I said, I'm not going to consider it. And they kept pressing, and I said, I told you 5 times I'm not going to consider it. I felt myself losing it a little bit, so I got up and I left the bench. So my character flaw, I guess, sometimes is to be occasionally, it's only happened a couple of times, but I'm human, I'm not going to deny it, where I had to get up and leave the bench because I knew otherwise I might pop. As honest as I can be.
Thank you, Judge. Thank you so much, folks. We appreciate you coming out and answering the questions posed. The next two groups that are going to be called up to the stage is Group 38 and Group 46. Groups 38 and 46. Group 38 is Jason Allen Rosner, Melissa Minks Donahoe, Linda Marie Leali, and Stephanie Camille Moon. Group 46 is H. James Curry, Maria Marcasian Weeks, and Walter Dale Miller. We're going to Group 38 sit on this end and Group 46 on the far end. We need some more chairs. Here's another one if we need it. Are we good or do we need more? No. Sit, please. I want to make sure we have enough. We have enough? Okay, fine. So let's start with Group 38. We're going to go in order of the ballot. So the first person I'll pose this question to is Mr. Rosner. When was the last time you tried a jury trial?
About a year ago.
And how many jury trials have you had?
25 to 30 jury trials.
And how many of those jury trials were for criminal cases?
All criminal.
Thank you. Ms. Donahoe, when was the last time that you tried a jury trial?
Death penalty trial about 6 years ago.
And how many jury trials have you had?
Over 30 that I've counted.
And how many of those jury trials were for criminal cases?
All of them.
Thank you. Ms. Leali, when was the last time you tried a jury trial?
I've not tried a jury trial. I've tried bench trials as well as I've had many evidentiary hearings.
And the bench trials were in what area of law?
Family and civil.
Thank you. Ms. Moon, when was the last time you tried a jury trial?
8 months ago.
And how many trials have you had in your career?
50.
And of those, how many have been criminal?
Probably about 46.
We'll take the estimate, that's okay. Thank you. All right, so actually, Stephanie, hold on to that microphone. We're going to start with you and go backwards for the first question. So, let me start with this. A judge, especially sitting on the criminal bench, must be a neutral arbiter that keeps an even keel in the most stressful courtroom situations. What role do you think emotions should play when sitting on the bench? What was a time in your life where your emotions got the best of you, and how did you handle that?
When sitting on the bench, I think that emotions should play a role in helping a judge to be empathetic in dealing with the particular matter that's before them. I think having life experiences that are in common with the person that's before you assists you in that matter. Professionally, a situation where my emotions got the best of me, probably...
Or personally, either one.
Or personally. I think, quite frankly, personally, and if you add that in, is when I miscarried my first child. That's when my emotions got the best of me, and I was pretty much a basket case for about 3 months.
And how did you handle that?
Lots of prayer. My husband and I sought counseling, grief counseling, and a month later I got pregnant again. That always helps.
Well, there you go. All right, so let's move to Ms. Leali. Thank you, Ms. Moon. Ms. Leali, I pose the same question. A judge, especially sitting on the criminal bench, must be a neutral arbiter that keeps an even keel, even in the most stressful courtroom situations. What role do you think emotions should play when sitting on the bench? What was a time in your life where your emotions got the best of you, and how did you handle it?
Well, I do think it's very important as a judge to stay calm. It's not your role you're not one of the parties, you're not one of the lawyers, you're a neutral arbiter. And so I actually serve as a court-appointed receiver, so oftentimes I'm serving in that neutral role. And so I understand that my role is not to get emotional, it's just to kind of understand the facts and try to help, at least in the receivership capacity, help folks reach the best decision. I can tell you that in one of the family case that I was mentioning that went to trial, bench trial, I would say that at one point I did a little bit get somewhat, my sister was with me, she said, "You got angry," because I just objected to the introduction of some evidence that I thought was going to be kind of salacious, and it went that way, and it was even worse than expected, and the judge basically cut the witness off. So I would say at that point in time, I did definitely lose got a little angry at the situation.
Thank you, ma'am. Ms. Donahoe, you're up. I guess the same question. What role do you think that emotions should play when sitting on the bench? What was the time in your life where your emotions got the best of you, and how did you handle that?
To be honest, I think that's a good question because we should be neutral as much as we can. But how should the emotions affect us as a judge? And I've been doing criminal law for so long and have seen so many things and have felt so many emotions in the courtroom. And I haven't thought about how that might affect me when I sit on the bench. So I have to say that I'm not going to be able to be emotionless. I imagine that the person standing in front of me with their case from the defense side as well as the victim side is going to affect me. I think I should let that happen. I think I should feel those things, but maintain composure and let those things ruminate in me while making a decision. So I don't want to let all that go.
And what was the time in your life where your emotions got the best of you, and how did you handle that?
I can think of this Cholo case that I handled a few years ago in front of Judge Rothschild, and I was so angry at that case, and all I could think to do was go back to the office and just draft motion after motion after motion and pepper him with those for him to deny within 2 minutes. And then I went home, sat on my porch, and drank white wine.
I hear that works pretty well. Mr. Rosner, I pose the same question to you. What role do you think that emotions should play when sitting on the bench? And what was the time in your life where your emotions got the best of you, and how did you handle that?
Thank you, Jason. Well, just an overarching thing with the responses I have is that I'm not going to have to tell you how I would do things or how things should be if I was going to be elected as judge. Because as not many of you know, I've been a traffic hearing officer for 6 years. So I've been put in stressful positions where emotions come into play in traffic court. Because people who do traffic court know the people who you're representing, they care just as much as everybody else about their case. That $150, $200 to the pro se that comes up in the Hollywood courthouse, which you've all probably been in at some point in traffic court, and they're standing right in front of you. You've got to be able to assess the emotions that are coming your way to be able to diffuse anything that can possibly happen in that courtroom. As a person who sits in front of the courtroom, one of your jobs is to ensure that everything is going smoothly, everyone feels that they've got their time in court. So for me, I can tell you that emotion doesn't come into play because of the experiences I've had in presiding over cases and knowing, okay, this is probably going to go this way. Don't get hot about it. Don't get too happy or sad one way or another. Because also when you're on the bench, when you're sitting as a hearing officer and people see how you're reacting, they may think one thing or another. And I know the jury instructions also say.
Thank you, sir. Your time has expired.
Perfect.
No, I think we're gonna move on here because we do have to keep moving. We are gonna start with you though, Ms. Ross, so hold on to that microphone. What is your judicial philosophy, or what would be your judicial philosophy as it relates to plea negotiations between the parties? And what role, if any, do you believe that the court should play in those negotiations?
As far as the court becoming involved in negotiations with pleas, I think it only should occur in instances where they're invited to. With plea negotiations, I know as an attorney, there's a lot the judge does not know that goes into those negotiations. Strength as a defense attorney for the past 14 years, I know the strengths of my case. I know the weaknesses of my case. The state knows the strengths and weaknesses of theirs. And we as attorneys came to our agreement. So for a judge to just, without knowing what we know about the case, become involved and maybe reject an offer, I don't think it's proper. But as with all cases, you have to take them individually. You have to take it for what it is, and each case, some cases may involve where you want to get involved, but I think for the most part, I don't think it's proper.
Thank you. Ms. Donahoe, pose the same question. What would your judicial philosophy be as it relates to plea negotiations between the parties, and what role, if any, do you believe the court should play in those negotiations?
First, I would never reject a plea negotiation made between the parties. I would always accept that.
Why?
Well, I believe that the lawyers know the cases and they're presenting a negotiated agreement to the court, and the court is accepting that based on the trust and of the bar that they're doing right by the client, that the state, that the defense is making, accepting the offer that the state has made. And generally speaking, in my experience, when courts reject offers, it's because I mean, they usually want to do something harsher. I'm just speaking about my experience over the years, and I don't see that as something that I would get involved with. So I generally would accept offers that were, negotiated pleas that were brought before me.
Thank you, ma'am. Your time has expired.
So I can't answer.
Ms. Leali, I pose the same question to you. What role, if any, do you believe that the court should play in negotiations between the parties?
I mean, obviously, I'm not a criminal lawyer, so I'm looking at this from a different perspective. It is my understanding that the rules and statutes governing plea negotiations don't really contemplate the involvement of the court. So in that regard, I would tend to concur with Mr. Rosner. I would potentially foresee Alan Rosner, excuse me, thank you. I would potentially foresee a situation where I could potentially ask, was the arresting officer communicated with regard to the plea negotiation? But I think that's pretty much the extent that I would get involved.
Thank you. Ms. Moon, we want to make sure that cable, yeah, there you go. Thanks, Jason. Ms. Moon, I pose the same question to you. What would your judicial philosophy be as it relates to plea negotiations, and what role, if any, do you believe that the court should play in those negotiations between the parties?
My judicial philosophy regarding plea negotiations would be to allow the parties to do their jobs. Let the defense make their appropriate representations, the state theirs, and then the negotiated resolution is presented to me. I would make an independent review of the plea negotiation to determine if I thought it was appropriate as well, and that would pretty much be the extent of my involvement.
Thank you so much.
Absolutely.
We're going to move on to group 46 now. So that's going to be the other end of the table. Let's pass that microphone down. Group 46 is H. James Curry, Maria Marcation Weeks, and Walter Dale Miller. All three are with us this evening. Thank you for coming. I pose to you first the three short questions, and we will go in order of the ballot. So, Mr. Curry, I ask you, when was the last time you have tried a jury trial?
Maybe 3 or 4 years ago.
And how many jury trials have you had in your career?
2, 1 let out before we went to trial.
And how many of those jury trials were for criminal cases?
Both.
Thank you.
But let me just add to that I'm primarily in juvenile. I'm assistant general counsel. So
I understand. I appreciate your answer to the question. Thank you. Ms. Weeks, when was the last time that you tried a jury trial?
A little over a year ago. I had to resign from the state attorney's office last August when I filed. So.
And how many jury trials have you had in your career?
Over 50.
And how many of those were criminal cases?
Probably about 45.
Thank you. And Mr. Miller, I pose the same 3 questions. When was the last time that you had a jury trial?
It was sometime earlier this year.
And how many jury trials have you had in your career?
I've had exactly 20 trials.
And
14 of them were not guilty.
A wonderful stat that I know many of us here appreciate. And how many of those jury trials were for criminal cases?
All of them.
Okay. So Mr. Miller, hold on to that microphone. We're going to start with you, and I'm going to pose this question to you first. Multiple children have died in the Department of Juvenile Justice custody in recent years. If elected and assigned to the juvenile bench, what steps would you take to ensure the safety of children who you assign to DJJ custody?
You know, when they have site visits to these facilities, they always give them a heads up and an opportunity to clean up their act before people that are reviewing or inspecting do their jobs. Off the top of my head, I've never thought of this before, but I think that unannounced site visits by a group of judges from all over the state would be appropriate.
Thank you. Ms. Weeks, same question. If elected and assigned to the juvenile bench, what steps would you take to ensure the safety of the children who you assign to DJJ custody?
I think a lot of it has to do with accountability. I think that when you shine a spotlight on a department and issues that are going on, people are more likely to make changes. I actually had the opportunity about a month ago with one of the juvenile judges and a group of women from the League of Women Voters who are part of the Juvenile Justice Committee. We actually organized a visit of the facility. And when we went to the facility, they obviously made some improvements before we showed up there. So it was unfortunate that we didn't get to see it in the way that it was, but the fact that they made the improvements when we got there, I think benefited the children that were there. So I think the more people go there and the more people visit and the more the department is held accountable for the standards that they should be keeping in order to protect these children, I think the more likely they are to do a better job.
Mr. Curry, you say that you are Assistant General Counsel, I believe, for the DJJ?
That's correct.
So then I would pose this question to you. If elected and assigned to the juvenile bench, what steps would you take to ensure the safety of the children who you assign to DJJ custody?
The first thing I would do is anytime a child or an attorney came to me with a complaint, I would investigate it. I would order an investigation. I would ignore no one. That's the first thing. And I'm going to reiterate, because I represent the secretary, I'm not going to hide behind that. I'm going to reiterate, I think the service that the Miami Herald did by exposing the things that happened in the department was a service to this community. None of us who work for the department can stand for that. The issue of funding for the detention care staff and the recent increase for the detention care staff has to be something that we put squarely on the state legislature. Secondly, the train left the station with contracted programs, okay? 20, 30 years ago, we made a decision in this state that we were going to hand over
No, sir, I appreciate your time has expired, but I'm going to let you finish your thought.
No, but not just in juvenile, but in adult. We have a private industry running our prisons for profit. And so we must be diligent when you have that. Kids should not be for profit.
Thank you, sir. So I'm going to pose this question. It's kind of a multi-part question I'm going to pose to the entire group, and then I'm going to ask that Mr. Curry answer first, and we work our way down the line. Maria, you are a former prosecutor. Dale, you are a public defender. Mr. Curry, you represent the government. Maria, if a criminal defendant appears before you, why should they feel that you're going to be fair? Dale, if a victim of a crime comes before you, why should they feel that you're going to be fair? Mr. Curry, if someone is suing the department before you, why should they feel you're going to be fair? How will you separate your professional experience from the necessity to be a neutral arbiter?
First of all, I won't be working for him anymore. One of the things that we have to do as attorneys and as individuals is be committed to what we do. I'm running for a judge because I'm committed to do that job and to do it fairly. I'm here to serve. Once you're a judge, you're no longer answering to yourself. You're there to serve the people. And you have to put the people before yourself. And that's what I promise I will do.
Thank you, sir. Maria?
It's true that I was a state attorney for a number of years, but in addition to that, my husband's also been a criminal defense attorney for almost 20 years, so I think it makes me very balanced because I've been able and I've had the opportunity to see both sides. The things that most prosecutors don't hear because we're unable to speak to the defendants, I've heard through him, and the things that most defense attorneys don't get to hear by speaking to some of the victims and the witnesses in the case, I've had the opportunity to do that as well. I also am being supported by a lot of criminal defense attorneys during this campaign, and that's because every criminal defense attorney that's ever dealt with me has known that I've always been fair, straightforward, and honest when it comes to my cases, and I wouldn't be any different when I was a judge. I would consider all of the facts from all of the lawyers, and I would be fair like I've always been.
Thank you. Mr. Miller? Dale?
Jason, as you know, I was in the Navy, and when I was in the Navy, I thought and acted like a sailor. And when I graduated from law school, I worked in private practice, civil attorney in Admiralty. And when I was in that job, I acted and thought as a civil attorney in Admiralty. During law school, I did 3 internships with the state attorney, including my CLI. And during those 3 internships, which amounted to about a year, I thought and acted as a state attorney. For the past 12 years, I've been a public defender, and I have thought and acted as a public defender. When it is time for me to take the bench, I will think and act as a judge.
Thank you. Thank you, candidates. We appreciate you coming tonight and for your answers. Next up, we have groups 36 and 42. Groups 36 and 42. Group 36 consisting of Sherry Beth Afric Olofsson and Kristen Weisberg-Padowitz. Group 42 consisting of Richard Brian Kaplan and Judge Michael Newsom. We'll have group 36 sit closest to me, and group 42 sitting in that something of a color side over there. It's tan? All right, no, I'm colorblind. Can't help it. Or color deficient. Everybody start going, what color is this suit? Is this tie blue? Get that a lot. All right, well, thank you so much for joining us, folks. I'm going to start with the same 3 short questions we've asked everybody else. And we are going to start with Ms. Afric Olofsson. When was the last time you tried a jury trial?
I began my career over 30 years ago with Alan Schreiber's office when he was the public defender.
So was your last jury trial 30 years ago?
That was the last time I was actually in a courtroom.
Okay.
My subsequent practice has been with large law firms. My role was primarily as a rainmaker. I brought in large financial institutional clients.
So let me ask again, when was the last time you tried a jury trial?
The last time I physically was in a courtroom trying a jury trial was when I was with the public defender's office.
So about 28 years ago?
About 20 years ago.
Okay.
My subsequent experience has been involved in the strategy and pleadings, but the way it works is
I'm only
you're not
concerned with jury
courthouse.
trials at this time. So let me ask his follow-up is how many jury trials did you have during your time at the public defender's office or in the rest of your career?
It was about a year, so I would say, I don't know, maybe 15 or 20. And then during the financial crisis, I would say probably 300.
300 jury trials?
Well, most of them were actually settled, but they were, some of them were resulted in jury trials. They were not
So
criminal.
if they didn't settle, they're not a jury trial. So my
Right,
question to
only-
you, ma'am, is how many times did you appear in front of a jury trying a case?
Oh, no, I was a rainmaker, so I wasn't in the courthouse.
Thank you.
Sure.
And Ms. Padowitz, the question's to you. When was the last time you tried a jury trial?
About 12 years ago,
And how many jury trials have you had?
about 75,
And how many of those jury trials were for criminal cases?
all of them.
Were they on the defense side or the prosecution side?
Defense, I only did bench trials. Jury trials were all prosecution.
Thank you, ma'am. So now we are going to go on to the substantive questions. And away we go. We'll start with you, Ms. Padowitz. The Florida legislature has taken away judges' discretion in minimum mandatory sentencing. How do you feel about the legislature taking that discretion away from our judges?
I think that the legislature is the one that makes the laws. I think that as a judge, I have to be, as you stated previously, the neutral arbiter of what's going on before me. I will not be in a position to change that as a judge, and I don't think a judge should be trying to change that from the bench. I believe that in my experience of trying 75 jury trials, I have seen the courts, many different judges in different courtrooms, and the way they've handled having discretion and not having discretion. And when you don't have discretion, you don't have discretion. But when you do, you want, as the public, I would think you would want somebody who has tried cases and been in the system in that regard to have that knowledge of seeing the good, seeing the bad, and I always say it's kind of like dating. You are attracted to certain things, but what you start to...
Thank you, ma'am. Your time has expired.
Okay, sorry.
Ms. Afric-Olsen, I pose the same question to you. The Florida legislature has taken away judges' discretion in minimum mandatory sentencing. How do you feel about the fact that the legislature has taken that discretion away from judges?
So I feel it is the legislator's prerogative to do that. I have actually been a lifelong student of American government, and I'm a huge fan of our founding fathers. I think they were brilliant for the 3 branches that they created. But I also do believe that the 3 branches need to communicate with each other. And I think it's a judge's responsibility to step off the bench and outside the courtroom and give those legislators some feedback when something really isn't appropriate and doesn't work. In my own personal opinion, really having begun at the public defender's office, that's been my lifelong perspective, I have to say. So child welfare, mental health, all of the issues that I think are inextricably intertwined with our criminal justice system are things that folks in Tallahassee have no idea about. And I think that judges who are sitting right there behind closed doors on every case need to have some discretion, because there are factors and there are lifelong implications to decisions that judges make that extend far beyond the jurisdiction of that one case. And the legislators have no idea about that. So I think it's a really important factor, and I really think judges should have discretion.
Thank you, ma'am. Hold on to that microphone because I'm going to pose the next question to you first. What is your biggest character flaw, and how do you address it?
It's a great question.
That's why I asked it.
I would say that I'm probably a workaholic, and that's probably what my family would say too. I try to deal with that by compartmentalizing a little bit, but I really love what I do. And what I do also extends beyond, professional boundaries sometimes. I mean, I've been a Supreme Court certified mediator for the last 30 years, and I've mediated some really, really, really tough cases.
In civil cases?
In civil cases. Yes, no, in civil cases. A lot of foreclosure work, but all areas. So employment, with a lot of accusations, harassment, family law, divorce, probate, and it's really hard to leave that at home. And I think that's probably my biggest flaw. I think a lot about those situations. I actually ran a nonpartisan national think tank for a while, which was wonderful. We did a lot of work with pay equality, but that then leads to a lot of other involvement. I mean, it's hard to separate. It's been very hard for me to separate work from my real life because I've always worked on issues that I care about.
Thank you.
The other flaw is that I keep talking sometimes when people say time has expired.
Many of the board members of BACDL would say that I have the same problem. Ms. Padowitz, I pose the same question to you. What is your biggest character flaw and how do you address it?
My biggest character flaw. My flaw is actually also a blessing in a way. My passion, I think, sometimes can be a flaw. When I'm involved in something, I am involved all the way. I don't do anything halfway. So that part is hard to separate work from home, from campaign, from raising a family, and it gets me frustrated. It's very frustrating to feel that I'm lacking in an area because I have another demand in another area.
Thank you. All right, we're going to move on to Group 42, Richard Brian Kaplan and Judge Michael Uson. Mr. Kaplan, I'm going to start with you. When was the last time you tried a jury trial?
I have not. I'm a civil attorney. I do bench trials.
Okay. Well, then the next two questions are going to have the same answer, so thank you. Judge Uson, I'm going to pose the question to you. When was the last time you tried a jury trial?
Well, not as presiding over one?
No. As a lawyer, when was the last time you
So
tried
that would have been right before I took the bench in December of 2009. I took the bench in 2010. It was a homicide.
And how many jury trials had you had in your career?
I stopped counting at 200 jury trials to verdict.
And how many of those jury trials were for criminal cases?
About 98%.
Okay. Judge, I'm going to ask you to hold on to that microphone. This question is a little varied for each of you, so I'm going to ask the part that is specific to each individual candidate. Judge Uson, why should Broward voters trust you enough to keep you on the bench?
Well, I think they can look at...
Could you speak into the microphone, please? I want to make sure that our people can hear us.
Better?
Yes, thank you.
All right. I think they can look at a 9-year record of what I've accomplished on the bench and see the types of cases I've presided over, the reputation that I've garnered for being fair, efficient, respectful, and you can look at the opinions that I've written in an appellate capacity. You can look at the orders that I've authored. You can look at the 4th DCA and see that by and large I'm affirmed routinely, and it's been very rare occasion that I've been reversed, and that's probably what you want to see in a judge is someone who understands the law and knows how to correctly apply it.
Thank you. And Mr. Kaplan, the question I pose to you is, why did you choose to challenge Judge Uson specifically?
Well, we're not able to criticize judges. There are reasons that I picked to run in this race. Some of them include cases that have gone in front of the judge. Some have also included some of the issues dealing with racial disparity in sentencing. And so this was a division that I work at the Regional Council, the other public defender office. We don't have somebody assigned in this division that is full-time. So this was the race that I've chosen for a variety of reasons. But if I can also take a few seconds to also address the first question, I've done a number of bench trials, including in dependency.
Thank you, sir. Appreciate it. The next question, you can hold on to that microphone though, because I am going to ask you the second part of the question, which is, what is or would be your judicial philosophy on sentencing in criminal cases?
Well, obviously I'd be following what the guidelines are. I'm not an activist type of person. I read the law for the way it's written, and I will enforce the law as it's been passed by the legislature and make sure that I am fair and impartial.
Let me ask you a follow-up to that. Do you believe that judges should have more discretion in sentencing in criminal cases?
Like previously answered here, I would say that I'm going to follow what the legislature has passed, but I do believe that there should be some more discretion given to the judges in sentencing. Absolutely.
Thank you. Judge Usan, I pose the same question to you. What is your judicial philosophy on sentencing in criminal cases?
Well, I think judicial philosophy comes down to being fair and looking at each case on its individual merits. There are no two cases that are the same. There are no two defendants that are the same. Each case brings with it unique facts and circumstances and unique backgrounds. And you have to take all of those things into consideration to fashion a sentence that best meets the needs of the community and the needs of the defendant and the ends of justice.
Do you believe that there should be greater discretion in judges' hands when it comes to sentencing?
Okay, I don't want to get in trouble here with my friends in the legislature, but I have often said that if you have not sat on the bench, you don't realize just how often there are restrictions on what we can do. And you know, folks will come up and say, well, you know, you're the judge, why don't you just rule this way? But well, you can't just do that, and you can't just sentence how you want. And minimum mandatory sentencing, I think, it can be problematic, and as someone else expressed, I'm not quite sure how someone in Tallahassee today has the foresight to know what a defendant standing in front of me 5 years from now, what their particular circumstances are. And when you make something a mandatory sentence, you take away the discretion of the judge, you're doing a disservice.
Thank you so much, sir. Candidates, thank you very much for coming.
Thank you.
In the last group, they're going to be front and center. It's going to be like a battle royale. Is Group 43. That is Karen Elizabeth Berger and Dan Casey. I'm going to ask you each to sit at a different color tablecloth. Nah, you can sit together.
I like red.
So since you two are the only group this time, I have the same questions prepared initially. I have two substantive questions, and we'll see. Maybe I'll put a little extra heat on you. But let's start with this. Ms. Berger, when was the last time that you tried a jury trial?
I have not. However, I've handled a multitude of civil bench trials. I've also handled a lot of evidentiary hearings, including very contested attorneys. That's correct.
Thank you.
However, I have been part of voir dire as well as appellate counsel. Thank you.
Ms. Berger. Mr. Casey, when was the last time that you tried a jury trial?
I think about 10 or 12 years ago.
And how many jury trials have you had in your career?
I haven't counted, but it's well over 100.
And how many of those were for criminal cases?
Oh, I would say maybe 75 or 80%.
Thank you. We're going to give the microphone back to Ms. Berger. Ms. Berger, let me ask you this. What ways would you run an efficient courtroom without impeding on the due process rights of defendants and the other parties that are involved in the case?
That's a great question, and obviously
And why I asked it.
I know, you've said that once or twice before. But I am going to speak from my experience in mostly civil litigation. I do believe that obviously efficiency is a concern on our dockets. I believe that if you have a if you have a motion calendar, it needs to be limited to 5-minute motions, and if it's something more, you absolutely need to special set it. I see that all the time where a lot of attorneys feel that they can just set whatever they want, and that's number one. Number two, I think that a judge needs to be prepared ahead of time and needs to review everything that's been filed by either side, and I think that that absolutely will help with the efficiency and moving through the docket so that the judge is absolutely familiar with what is going on in that case, the facts, and the allegations, and et cetera, and also the arguments made in the motions.
Thank you. Mr. Casey, I pose the same question to you. In what ways would you run an efficient courtroom without impeding on the due process rights of the defendants and other parties involved in the case?
Sure, I think that the way that you manage a courtroom is the way the courtroom goes, and the expectations that you set in the beginning is what you end up getting. So I would set expectations from the beginning of how people should appear in my courtroom. I would expect people to be prepared. And then I would acknowledge that by being as prepared as I expect them to be. I would set down kind of the rules of how people should conduct themselves in my courtroom up front, so that everybody knows that the culture in my courtroom is such that it will be effective, it'll be efficient, and that was about it.
Okay. Mr. Casey, I'm going to ask you to pass that microphone back over to Ms. Berger. Ms. Berger, what role or actions will you take to aid in reducing recidivism in the judicial system?
Recidivism. Can I have a definition, please, and use it in a sentence?
People coming back through the system,
Okay.
over the revolving door that,
Right.
that we often hear about.
Okay.
in the criminal justice system.
So, I'm sorry, can you repeat the question?
Sure. What role or actions will you take or have
Mm-hmm.
to aid in reducing recidivism in the judicial system? More specifically, the criminal judicial system.
Fair enough. And I think that really is an issue. I think that unfortunately, young children, once they get involved in the system, I think you do see a lot of repeat offenders, and it's because of really once they're in that system and maybe they don't know anything else. And I do really believe that rehabilitation is possible. So I do think that there needs to be more programs, hopefully in place, but to help children once they've actually done the offense. However, I think more importantly, and absolutely most important, we need to actually have things in place to prevent anyone from getting in the system from the very get-go. And I think that comes down to education. I think that comes down to education not only for the public, but also for attorneys and everyone involved in the legal system. And I think that absolutely is the number one way that we can prevent the repeat and the unfortunate series that we have right now.
Thank you, ma'am. Mr. Casey, same question to you. What role or actions will you take or would you play in aiding the reduction of recidivism in the criminal justice system?
Jason, I think there are a number of ways that we can. In fact, some of them have already been started with the juvenile citation program, for instance, where you stop a child from having to be arrested and going through the trauma of the arrest and the stigma of the arrest. A similar type of a program for applicable adult offenders might also be a good idea. But I was a prosecutor back in the Dade County State Attorney's Office between 1981 and 86. And back then, on sentencing, for instance, we always argued 4 different parts to every sentence. There was general deterrence, there was specific deterrence, there was retribution, but there also really was rehabilitation. Rehabilitation was a real part of the criminal sentencing and actually how prisoners were treated after they were doing their sentence. I think there has been a void in the rehabilitation piece, including substance abuse and mental health and all of the other parts, training and counseling. I think there has been an absence of the rehabilitation piece from the sentencing world that I think needs to return.
Thank you. So I'm going to ask you to stay up there because we're going to ask another question in this group. Often we hear people say that judges shouldn't be young because they don't have the professional or life experience to be able to preside over very important cases. And often we hear people say that judges shouldn't be older or nearing the end of their career because they're too set in their ways and they're going to be crotchety, old people on the bench, and we don't like to deal with them. Mr. Casey, why are you not too old to be one of Broward's newest judges? And Ms. Berger, why are you not too much of a neophyte to be one of Broward's newest judges?
Sure, thanks, Jason. Anyone who knows me knows that I am my chronological age, but I actually have this 12-year-old deep inside me that comes out a lot. It's the way I look at the world. I always tell people that you need a certain amount of time to gain the wisdom that you need to do in order to have the job. You make serious decisions as a judge, and you need to have so many life experiences. And good golly, I've had a lot of very fine life experiences. Judges need to be smart. but they don't need to be smart in 3 different ways. They need to be intellectually smart. They need to be street smart, but they also need to be wise, and wisdom comes with age. Wisdom comes with life experiences. And so I've benefited from a wealth of life experiences, and I always tell people, I have enough miles on the odometer that I know where the roads will take me, but I have a limitless amount of gas in the tank still left.
Thank you, sir. Ms. Berger?
Great, thank you. So I think that being young is absolutely, first and foremost, a benefit. I absolutely want to make this not only a career so I can serve Broward County, number one, but number two, I absolutely will be held accountable for all of my actions if I then seek re-election thereafter. Unfortunately, Mr. Casey is only able to serve 1 term. And really with that too, with regards to being young, I don't think it necessarily dictates being someone who can absolutely figure out how to be a judge. I think a judge needs to be someone who follows the rules. And I have to mention that unfortunately my opponent is the only judicial candidate who has actually violated election laws and actually has been fined for failing to meet simple deadlines.
Ma'am, I'm
So
just gonna ask you to stick to the answer
absolutely,
the
but I
question.
want to
We're
mention
gonna
that again
ask.
is that you're asking a question as to age and painting a picture that that actually is something that should be taken into account. But what I think should be taken into account is someone's ability to play fair and follow the rules.
Thank you, ma'am. Your time
Thank
has
you.
expired. Thank you, candidates. We appreciate everybody who has come out here tonight. We hope that you have been educated and enlightened on our candidates for Circuit Court here in Broward County. This has been Facebook live streamed throughout the entire event. It is going to be up for replay. We encourage everybody to share it on your Facebook pages, on social media. Make sure to tag BACDL in your posts. And if you have any questions about any of these candidates, feel free to reach out to our executive board and we can get you in touch with their campaigns. Thank you so much. Get home safely.